D, they had the potential, given the circumstances prevailing in the country at the time, to significantly diminish public confidence in the viability of the Kenyan state and its ability to protect the lives and properties of its citizens. E, they go against the constitutionally prescribed oath of allegiance of the office of the Deputy President under Article 148(5)(a) of the Constitution, which requires the Deputy President to obey, preserve, protect and defend the Constitution and all other laws. Rigathi Gachagua, how do you plead to ground not guilty?
Not guilty.
Ground 10, gross misconduct, that is insubordination. As stated in ground 9, the phrase gross misconduct generally refers to behavior that is very unpleasant, disgusting, very rude. This is from the Oxford Advanced Learners Dictionary. Therefore, open or public insubordination of the President, who is the head of state and government under our constitutional framework, is gross misconduct. As stated in the preceding parts, Article 147(1) of the Constitution designates the Deputy President as the principal assistant of the President, who shall deputize for the President in the execution of the Presidency. He has opted to run a smear campaign against the Presidency for political expediency. Further, whereas Article 147(2) of the Constitution requires the Deputy President to perform the functions conferred by the Constitution and any other functions that the President may assign, His Excellency Rigathi Gachagua is openly sabotaging the state's efforts in agriculture, including the coffee, tea, sugar, and milk sectors, which the President tasked him to oversee. To illustrate, A, His Excellency Rigathi Gachagua has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed minimum returns that would benefit smallholder tea farmers. B, His Excellency Rigathi Gachagua has influenced his family members, allies, associates, and proxies to take control of a local cooperative society, name withheld in Madeira, which they are financially hemorrhaging. Your Excellency Rigathi Gachagua, how do you plead to ground 10, guilty or not guilty?
Not guilty.
Ground 11, gross misconduct, that is bullying. As stated in ground 9, the phrase gross misconduct generally refers to behavior that is very unpleasant, disgusting, or very rude. This is from the Oxford Advanced Learners Dictionary. Section 34 of the Leadership and Integrity Act provides that a state officer shall not bully any person. Bullying includes repeated offensive behavior that is vindictive, cruel, malicious, or humiliating, and is intended to undermine a person. For the past 2 years, His Excellency Rigathi Gachagua has persistently bullied state and public officers. To illustrate, A, His Excellency Rigathi Gachagua bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited, his proxy company. Crystal Limited has submitted a fake bid bond with the sole intention of fraudulently acquiring public property. B, His Excellency Rigathi Gachagua routinely bullies public officers in national security organs whom he subjects to public attacks and humiliation. C, His Excellency Rigathi Gachagua routinely summons procurement officers in ministries and state institutions and instructs them to direct the procurement of goods and services in a particular manner. D, in the presidency, His Excellency Rigathi Gachagua identified public officers who he thinks stand in his way of creating dominance within government and political kingship, and he has severely threatened, intimidated, and harassed them. E, in 2023, His Excellency Rigathi Gachagua used his position as a Deputy President to intimidate public officers and a contractor to divert materials meant for the construction of the Kilifi-Malindi Road to tarmac a private road to Vipingo Beach Resort, a hotel associated with him. F. His Excellency Rigathi Gachagua uses his constitutional power as Deputy President solely to implement sectarian, parochial, and personal interests that seek to profit him. Your Excellency Rigathi Gachagua, how do you plead to ground 11? Guilty or not guilty?
Not guilty.
His Excellency the Deputy President, you may take your seat. Counsel for the National Assembly, you may proceed to respond to the objection that has been raised by Counsel for the Deputy President.
Perhaps, Mr. Speaker, sir, just before Counsel responds to my application, for efficiency and expediency, permit me also to bring to the attention one more application in respect to the documents that were served upon the Deputy President. Mr. Speaker, sir, by a letter that you referred to, sent from the Speaker of the National Assembly to the Speaker of the Senate, the Speaker of the National Assembly did submit the documents that emanated from the National Assembly.
Counsel for the Deputy President, take your seat first. You'll have your moment.
Mr. Speaker, sir, if I could take a few moments this afternoon to respond to the preliminary objection that has been raised. I have three quick issues in response to that objection. Number one, the Constitution of Kenya at Article 77 is the primary law that then speaks to restrictions on activities of state officers. In particular, Article 77(1) reads, "A full-time state officer shall not participate in any other gainful employment." Mr. Speaker, sir, that article introduces one critical variable: gainful employment. Mr. Speaker, sir, gainful employment has been defined within our laws. Specifically, Section 26 of the Leadership and Integrity Act has defined what would amount to gainful employment. If I may, Mr. Speaker, sir, Section 26(1) reads, "Subject to subsection 2, a state officer who is serving on a full-time basis shall not participate in any other gainful employment." It then proceeds at subsection 2 to say, in this section, gainful employment means work that a person can pursue and perform for money or other form of compensation or remuneration which is inherently incompatible with the responsibilities of the state office, or which results in the impairment of a judgment of a state officer in the execution of the functions of a state office, or results in a conflict of interest in terms of Section 16. And so to our response, there has been no assertion that learned senior counsel James Orengo, by representing a party before this House, has participated in gainful employment. In any case, what evidence has been tendered before this Honorable House to speak to that fact? Mr. Speaker, sir, that is a question that has also received judicial interpretation. If I may, in the election petition number 3 of 2013 filed in the High Court in Busia, similar applications a similar application was made, again objecting to the participation of the Honorable James Orengo Senior Counsel in the proceedings in that matter. The judge handling that case interpreted both Article 77 as read with Section 26 of the Leadership and Integrity Act, and had this to say at paragraph 28, that it had been argued that by representing a party in an election petition, the Honorable Senator would be compromising the political neutrality of his office. I would not agree. Section 23 of this Act is a provision on political neutrality expected of appointed state officers. Honorable Orengo holds an elective position. Elected members of Senate are politicians. The provisions of Section 23 do not apply to them. So even if it was to be assumed that, that by representing the third respondent, Honorable Orengo is pursuing a political agenda, that would not be inimical to his office as a member of the Senate. And so, Mr. Speaker, I submit that unless there is material that will be tabled before this House, that by appearing for a party before this House, then the Honorable Mr. James Orengo Senior Counsel would have engaged in gainful employment. That objection does not stand any merit. Number two, the second test that has been applied by courts is the test around conflict of interest. Again, Mr. Speaker, our courts have had occasion to interpret what amounts to conflict of interest. In a case determined by a 5-judge bench, a case reported in our laws, that is EKLR 2018, the case of Philomena Mbete Mwilu versus the DPP and two others, the bench, in determining and dismissing a similar application, defined conflict of interest as a situation where one is confronted by two different interests, so that serving one interest would be against the other. Mr. Speaker, sir, there hasn't been any conflict of interest that has been, even in the least, mentioned by to the participation of Senior Counsel, the Honorable James Orengo. Finally, has there been an indication as to any prejudice that could be occasioned by the participation of the Honorable James Orengo Senior Counsel before this House this afternoon? To the best of my recollection, none has been mentioned. Is counsel, for instance, saying that the participation of the Honorable James Orengo before the proceedings in this House, their defense when they get the opportunity to present the case? I'm just asking myself. That has not been said. In any case, Mr. Speaker, sir, if that was to be the case and the fear that has been presented, then as advocates, as counsel, we operate within very clear and defined rules. Those rules are meant to ensure that a party before this House, just like would be a party before any court or any other forum, does not suffer or does not have a compromise to their rights to fair hearing under Article 50. In the absence of any prejudice that has been mentioned before you, we urge that that objection be dismissed. I've also had occasion to look at the case that was referred to by my learned friend, Mr. Njiru, and with respect, that case turned on two critical points. The first one being that the participation of the Honorable James Orengo as a senator in that matter was said to have had the potential of compromising his participation in the Senate proceedings, because then he was a senator. He is not a senator as we speak. So that then marks a significant difference or departure between what led to the finding in that decision and what we have before you. The judge
for here as counsel earning a fee, and that is what Section 26.
Senior Counsel, don't go to that on the table. Has the evidence of him earning been put on the table?
Mr. Speaker, sir, the only presumption
No, we are not going to presume facts. We are not.
Mr. Speaker, sir, I am well guided, but may be noted and may go on record that the grounds laid by Section 26, subsection 2, have not been rebutted by the submissions made by counsel insofar as the gainful employment in these proceedings is concerned. Number two, he is here as a governor of Siaya County, not as a senator. And as such, the petition number 3 of 2013 is distinguishable from the fact that he's here as a serving governor. And that is what Section 26, subsection 2 speaks to, and that is also equally the provisions of Article 77 of the Constitution. Further to that, Mr. Speaker, sir, the test of prejudice is a creation by counsel. It is that at Section 26, subsection 2, and Article 77 speaks to. The only test is gainful employment. Unless that one is rebutted, the general presumption, again, Your Lordship and Mr. Speaker, sir, and that is a legal presumption, unless it is rebutted, is that he is here for a main purpose to earn a living. Mr. Speaker, sir, I leave that to the House to make a determination. Permit me once more to move the House with my last and final application. Yeah, insofar as, Mr. Speaker, sir, these proceedings are in issue. Mr. Speaker, sir, on the 8th of October, 2024, this House was served with a resolution from the National Assembly by the Speaker of the National Assembly via the letter that the Speaker of the Senate referred to. That letter, Mr. Speaker, sir, appears at page 547 to 548 of volume 5 of the National Assembly's bundle of document. There is no, Mr. Speaker, sir, we were then served with 2 sets of documents, an affidavit dated the 11th of October, deponed by one Peterson Jomo Mushira. Our objection, Mr. Speaker, sir, is that that document, that affidavit, did not form part of the documents that were submitted by the Speaker of the National Assembly to the Speaker of the Senate. It's our argument, Mr. Speaker, sir, that this is new evidence. Further to that, Mr. Speaker, sir, we were equally served with a bundle of documents from the National Assembly, which is labeled as Volume 8A, which is also indicated as responses from various government agencies. Again, Mr. Speaker, sir, this is new evidence that does not find itself at page 547 to 548 of the bundle of documents submitted to you or to this Honorable House by the Speaker. The prejudice, Mr. Speaker, sir, is that our response was exclusively limited to the documents that we were served with. Further to that, Mr. Speaker, sir, it's our argument and our application that these documents will prejudice our case in the sense that, Mr. Speaker, sir, they will violate